Kefrey, a 30-year board member, passed away this last week, and on behalf of the board, I just want to express our deepest condolences to the family in this community. Obviously a pillar of this community.
For those of you who would like to join us, we will be having there's a celebration of life the family will be having for her at the New Life.
Call a couple names just so you know when you're on deck, and once that list is exhausted, we'll move on to the next one. So we'll start with Darlene Sikorsky, then Jack Schwartz, Larry Slott, and Jean Schroeder.
I just ask that you state your names and your address, please.
Darlene Sikorsky, 6412 County S. Sobieski. And thank you, board, for allowing me to speak today. I am against Title IX, and this is some of my reasonings that I have. Number one, there's no place in our schools for indoctrination of the woke agenda in our schools. Biological females should use the girls' bathrooms and play girls' sports. Biological males should use the boys' bathroom and play in boys' sports. Our schools are supported by the community, and we need to address and support the kind of community that Pulaski is here. And then also anything like drag queens or anything like that should not be discussed in our school systems. That's not proper time and place for this. And I hope you vote no for Title IX. Thank you.
Thank you, Darlene.
Thank you.
Jack?
Jack Schwartz. I've lived in Pulaski all my life. And to see what's happening with this, I can't believe.
We just state your address for us, please. State your address for us, please.
1004 Schwartz Road.
Thank you.
And Title IX by itself was fun. This destroyed. You're taking away, you're hurting both sides of the fence. The girls and the ones who need help. This is not a competitive thing. I I just think it's totally wrong. There's wrong and right, and this is definitely a wrong. And it shouldn't even be looked at. There's a lot of states I know that have this blocked by their governor right now, that they don't even have to look at it. And I don't think that'll happen here, but I think somebody's gotta stand up now and say, this is enough. That's all I gotta say.
Thank you.
Thank you. Larry?
I'm Larry Slatt, 142 Williams Street. I moved here to Pulaski in '95, spent 20 years in the Marine Corps before coming here, so I've seen quite a variety of life. I just want to read something really quick. Congress enacted Title IX in 1972 to protect women's sports, to create opportunities for women in sports and academically. Okay, and it's done a great job. Current administration took Title IX and has spun it on its head by redefining what sex is. The Supreme Court said in a decision early this year that there was a difference between sex and gender identity. And the administration just disregarded that, came out with an executive order in April that said we're going to order all our executive branches to redefine sex the way that we want it. Okay, this woke agenda that Jack talked about, it's nuts. It's killing you. It's killing people. Now, I know people have issues, and I know people have feelings about how they should be. You know, somebody says, hey, I think I'm a woman inside, or I think I'm a man inside. You know, you want to do that, fine. If you're doing it at home, fine. If you want to do a sex change operation when you're an adult, fine. Get it out of our schools. Keep it away from the kids. You can't take away from the girls in their athletics by having a male playing sports with them, just for an example, because you're hurting them both. You can't take away from one or the other. Provide for now you got three, provide for three. If you want to have a separate sporting activity for, you want to call them an alternative division, fine, I got no problem with that. But you're hurting your Title IX was designed to help the women and to give them the opportunities, and they take it away. And that's all I really got. I think if we have to look at this and say, is it right or wrong? It's probably wrong.
Gene?
My name is Gene Schrader. I live at 233 James Court, Pulaski here. I'm not a very good speaker. I don't even know what I put down to speak, but Bill Burmeister, fabulous person for our community. If he was here today, this wouldn't even be discussed. And I got a survey right here. I'm mailing it in. It's against Title IX. As soon as I'm out of here, it's going to the post office. Title IX is no good for our nation and for our children.
Thank you. Thank you.
Dan Laskowski, and then Troy Tetzlaff, and Brittany Downer.
Dan Laskowski, 3219 Rolling Hill Drive, Pulaski, Wisconsin. I'm sure everyone here this evening has the best interest of the school district at heart. If you were to ask the public about Title IX, they would have heard the term Title IX. However, the majority of them would be unfamiliar with its contents. When you mention gender identity, their eyes and ears open up. They see it different, they hear you speaking to them. A majority of the residents would say it's either boys or girls, men or boys. I talked to about 15 people on this, and everybody's sort of, they don't want to elaborate on it. They just want to men, women, boys, girls. I wasn't able to attend the last meeting. I had more questions than answers. And some of you ask questions, or sometimes you ask questions that you may already know the answers to. What is Title IX? A federal, state, law, bill, document? Where did it originate? Who wrote it? How many people wrote this thing, and how many people actually read it? There's probably 500 lawyers that did this. No offense if we got a lawyer in here. Probably 500 lawyers were involved in this. Who of us went to law school to understand it? Who's going to interpret it? And what does it really mean for our community? Who is responsible? We are all responsible. Everybody in this room is responsible for its contents. School administration, faculty, school board members, parents in the district and community. The elected board and school administrators have the duty of doing what is best for the district, students, sharing the views of the community. Don't let the outside interest input our community, our children's school district. Ask yourself, whose school district and community is this? Does it belong to us or is it somebody else's? I didn't know how to phrase this on the people involved for Title IX that, I don't even know, get special consideration, or whatever, consideration or whatever. But how aware are the fellow students in school, parents, and the teachers of these situations or these people or whatever? And a little food for thought, Title IX. Is it interfering with the meaning of education? Is it the best interest of our students in the use of our valuable resources, time, staffing, and energy? Let's continue to educate our student body, not confuse them, add adversity to learning, and make their future bright. People are people, kids are kids. They are all creative. We all know we will push it to a limit, kids or adults. Are we going to be a part of the solution, or are we going to be a part of the problem in the future? Thank you.
Thank you.
Troy?
I'm Troy Tetzloff, W1133 Middle Drive. I'm here tonight against allowing boys and girls to switch bathrooms, sports teams, locker rooms, hiding sexual confusion from parents, and punishment of teachers and students for misgendering or misuse of pronouns. It is just a common sense to not allow this. A fraction of a percent of people have this mental confusion that cannot handle their biological sex. There should be no reason we should change our complete way of doing things for a mental disorder. By allowing this, it is teaching our kids it is okay to change the sex God made us as. Many kids will try to change what sex they are just because it is cool or they want to be more competitive in sports, like a biological male joining a female sport. Sexual predators will take advantage of this. I am very disappointed that this is something that would be considered in our district. Implementing these policies will create way more harm than good. I know if there was a vote by people in this district, a majority of people would not vote for this. These issues have been created politically to divide us and create confusion in our society. It is our time to stand up for common decency and make tough decisions. This is a fight for what is right, even if there is a risk. I'm asking tonight to please not allow these rules to be implemented. There's no amount of money that the state or federal government could give this district to make it worthwhile. Thank you.
Brittany?
I'm Brittany Downer, 155 Main Street here in Pulaski. I'm here tonight in support of the new Title IX Policy 2264. And I strongly urge you to approve this policy. As you know, Title IX was enacted 50 plus years ago as a means to protect people from discrimination, not only on the basis of gender, but also disability, race, religion, etc. Failure to fully comply with the Title IX policies conveys a message that PCSD is complicit in discrimination, bigotry, and harassment. The PCSD mission statement states that our district's goal is to provide all students with the opportunity to achieve the knowledge and skills necessary to become contributing citizens in our diverse world. If we are to live our mission, then we must fully comply with all aspects of Title IX and demonstrate our commitment to equity and inclusion within our district. As the district's legal counsel stated at the last meeting, failure to fully comply with this policy puts the district at risk for private litigation. Not only would this have financial ramifications, but again would send a message to the public that is contrary to our mission. The district risks losing $2.7 million in federal funding if the board fails to adopt this policy. In a time when community members, including several of you here on this board, have endlessly scrutinized the district's spending, called for transparency, with regard to the recent referendum, why would we risk losing millions of dollars from our budget? As Superintendent Space stated at the last meeting, this would have detrimental financial impact to our students in our district. Again, as the district's legal counsel stated at the last meeting, this has nothing to do with gender identity. The district's legal counsel, student services director, business director, CISA, and most importantly, our teachers, the Pulaski Education Association, have all advised that you adopt this policy. I encourage you to trust their guidance and value their expertise. Gender identity is a hot button issue. We all know that, and I respect that. It's a divisive one at that. There are various opinions surrounding gender identity, bathrooms, sports, but again, that's not part of this, as our legal counsel has advised. This is strictly procedural. None of that is changing with this policy. As a public servant in what is supposed to be a nonpartisan school board, I encourage you to set aside your own personal socio-political ideologies in making this decision. The school's own mission statement requires that you must consider all students when making this decision. As the parent of a student with disabilities who receives special education services, this decision would have a dramatic impact on our child and many other students like her, not only in terms of program funding, but also protection from discrimination. Many families, including ours, seek or have sought to live in this community because of our schools, and particularly our amazing special education programs. Failure to fully comply with Title IX sends a message that families like ours and our children are not safe nor welcome in our schools. Again, I urge you to consider the many diverse Pulaski students and families and approve this policy. Thank you.
Thank you.
I have Jenny Rybicki, Aaron Sperduto, and Jonathan Whitcomb.
Jenny Rybicki, I have dual residence in the district, 831 Golden Eagle Court in Pulaski, W2390, County Road S in Angelica. When we talk about woke agendas, I think it's important to remember that gender identity is already part of our policies, and there's outside interests trying to make this issue to implement procedures and to handle complaints for discrimination and harassment into an issue of boys and girls in bathrooms and unfair sports advantages. It's not what this is. Those policies exist. I don't have a lot to say, in part because I'm shocked. We're supposed to be better than this as a community. We are supposed to rise above bigotry in all forms. And all children, regardless of race, religion, gender, or anything, deserves to have a safe place in our schools. It's just a shame that our current board majority does not believe that. Fiscal responsibility and commitment to students and teachers does not include gambling with $2.7 billion that is primarily used for students with special needs, nor does it stop at the implementation of consistent complaint procedures that protect our staff and district. Thank you.
Thank you.
Thank you. Aaron?
Aaron Sperduto, 4328 Williamsburg Court, Hobart, Wisconsin. My hope is that this district and school board adopts a position that provides clarity and protection for our staff as it relates to the Title IX policy and, of course, protecting our students.
Thank you, Aaron.
Thank you. Jonathan? Choose.
All right, my name is Jonathan Whitcomb, 704 Johnson Street. Didn't grow up in this community, but I've had siblings and a spouse that have grown up in the communities. Not really sure I can add a lot of context or opinions to what has already been espoused here. We're a community. We need to live together. We need to strive together. We need to come together as a community. We need to live as one. I have my extreme opinions as far as religion and as far as demographics and as far as religion. I feel very strongly about these things, but the one thing that never can never overcome is that we are a community. No matter who we are, who we're made up of, we are one. The division of the communities needs to cease. The conversations can continue because they are important. One point of view cannot supersede another in one way or the other. Because I am conservative does not mean that you're liberal and you oversee that, or the fact that any other opinions, whether you're trans, LGBTQI+, things I don't agree with, doesn't mean you can come in and overtake me. We need to work together. I can see these point of views. I want to work with these point of views, but I don't want to be forced to accept your point of views. No matter what side of the aisle that you are on, I respectfully decline the financial ramifications for this acceptance of Title IX need to be accepted. I don't think financial should be the reason we accept or decline anything. It should be our values as a community. We are a Christian community, and I stand with the Christian community. Baptized Lutheran, converted to Catholic, that is where I stand. Those are the beliefs that I have, and those are the beliefs that I will hold and perpetrate. I do believe that this is important to hold. And that is where I stand on the issue. I do hold that you guys please decline the Title IX. There are apparently items that are already in place for discrimination. We're a community. We need to treat each other as humans, as people, not based on sex, not on gender, not on the views that we hold. Let's just be people to people. Let's be good to one another. Let's say hi. Let's shake our neighbors' hands. Who cares who they are? Who cares what they think? Let's just come together as a community. That is all I have to say.
Thank you.
Thank you.
Okay, thank you all for your insight. I also appreciate everybody who reached out to the board through messages, calls, emails. I've read them all, and I assume everybody up here has. So we're here tonight to discuss two policies, policy 2266 and 2264. It's my understanding that you guys probably haven't seen much of 2264 yet. That's our new policy. If you line those two policies up next to each other, a lot of the verbiage is exactly the same. Policy 2266 is our current policy. I am not here to minimize your concerns around the verbiage. I share some of those concerns around the verbiage. But what you need to understand is we've been living under this policy. This policy already exists. It's not a new policy. That verbiage is in our current policy. So we're not changing, if this gets voted in, we're not changing that tonight. It's already here. It's been here. We adopted Neola in 2022, I believe. The board adopted those policies. We took that verbiage at that time. It's been here. That verbiage likely started, we have Bob Burns here. He's our legal counsel here tonight. That verbiage probably started in 2017. There was a case in Kenosha, Whitaker versus the Kenosha School District. That made it all the way to our 7th District Court. And at that time, they ruled on that, and that has been upheld at least twice in the courts now. That legal precedence is what is over the top of Wisconsin right now. We have to abide legally by that law. The policy is in place. It's not new. You can pull up our website right now and read it. Those words are already here. I understand your concerns. So Talked to a lot of lawyers in the last week. I just had another one call me before the meeting. I've done a ton of research. I've read more law than I have ever cared to read, Heidi. So I've done my research, I understand. So the board, we don't have a presentation tonight. We have legal counsel here. We have our administration is here. They're happy to answer questions. If we would like to know how this rolls out, we have a presentation ready if we want to see how the investigative piece happens in the new policy. I've talked to both people on both sides of this topic. Everybody agrees that part is really good for us. It gives us a lot of flexibility. Everything you guys described tonight, it gives us the flexibility in Pulaski to apply this how you want it applied, how we want it applied, how the parents in this district want it applied. That's the part that's changing tonight for Pulaski. The rest of it is already here. So I just want to make that clear. Here's my proposal. So
Can I ask you a question?
Yes.
I have one too.
We ended the meeting with a request for a second opinion.
Yes.
You sent an email to us indicating that you had a second
Yes.
opinion. I understand you met with attorney Bob Burns for that second
Yes.
opinion, and in the email you said you would spend some time
Sure.
letting us know what was said in that meeting. So if you and Bob could maybe fill us in, because I haven't been informed as to what has been discussed.
Very good. So we had Jeff Lacey here last time, and Bob shared with us exactly what I just said, what the legal landscape is right now. I just reiterated, took what Jeff Lacey told us and what Bob Burns told Steve and I when we met with him. That's the legal landscape in the education system right now. So that's kind of my synopsis of what I understand to be the legal landscape of what we're doing here. We have two policies. Most of the verbiage is the same other than the application. I've read both of them. There's minimal change other than the application, right? So, and you can ask some more questions. Let me finish what I'm gonna say, and then you guys can ask away. I would propose, if our administration agrees to it and our legal counsel agree to it, a lot of the concern is the changing legal landscape with the federal level right now and the Department of Education, the courts in Kansas, our court in the Seventh Circuit, the Whitaker case. This is all moving very quickly. I hope that we don't have to continue to talk about this every time the court changes. So I would like our policy to just give us the flexibility to adapt to the law. So in this policy, everywhere where it says the basis of sex stereotypes, sex characteristics, sexual orientation, and gender identity, I would like to change those words to say this policy covers harassment and discrimination on the basis of sex as that term is defined by applicable law. That's it. Let's simplify this. Let's take the words out. It doesn't matter. We have to follow the law. Everybody here has to agree with that, right? We have to follow the law. Every one of our workplaces has some type of harassment program in place. Pulaski Community School District has to have that in place. I would like to just simplify this, make the policy follow the law, and then we can just be done talking about it.
So does that care for taking that verbiage out? Legally, are we able to do that? And does that put our admin, so Julie, does that put you in any position if we remove that verbiage and we state following the law, and as that changes, as we know, appeals and things are going to come through, we are just always going to follow what the law for Wisconsin states?
I'm gonna ask Bob about the applicable law part.
All right.
No, I think that gives you the umbrella, if you will, of whatever the current legal landscape is. And as you mentioned earlier, we know what that is in Wisconsin. A lot of these other states are still, or circuits are dealing with cases. We have the Whitaker and subsequent decisions in Wisconsin. Eventually, if that changes through a U.S. Supreme Court decision, you're going to follow the applicable law. So I think that sums it up for you in that sense.
But question, Bob, does that? So if I'm understanding this right, so that is the difference between the two policies. I have them right here. That paragraph in there about sexual stereotypes and all of that. If we're saying change those words to whatever the applicable law is, that means this goes into effect, right? today.
Which is which? You're
This is 2264.
okay.
The paragraph in there that's been added, which makes these two policies, 2266, our current one, and this one different, says discrimination on the basis of sex includes discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. If I'm understanding this right, if we change the verbiage, even though it doesn't explicitly state this, you're saying we're bound by it, because that's currently the law. But if you could explain to us, so the Title IX is a federal mandate, right? A law, it's been in place for 50 years. Is this not just a regulation that the Department of Education is trying to push down versus a law? Maybe not in the state of Wisconsin, but at the federal level?
No, the regulations that are in place went through what's referred to as the rulemaking process, but they're applying the statute. Title IX is a statute.
Okay.
And so they are applying that through their rulemaking authority. What's being referred to as the new regulations, the 2024 regulations, do not add protection for anyone that wasn't already protected by the old regulations. That's, I think, the point that Jennifer was making. Most of the changes are, except they added more language about pregnancy situations, but to protect students who are pregnant. But the basic protections of the regulations haven't been changed. Who's protected by the regulations hasn't changed, and in our circuit that has been the same since 2017.
So you're saying in 2266 that same language should be in there? Because
Well,
it's not.
It's not. The language was expanded, but the coverage, and I think that's where Jennifer's coming from. By saying per applicable law, you're going to be current. But the 2266 refers to gender identity.
Correct. Sexual orientation and gender identity, that is correct, it's in there.
Right.
But all the other components that are added to the Title IX were not in there. So again, I'm just trying to understand. If we're saying applicable per the law, are you saying that if we put that general language in there, what law are we under today then? Well, tomorrow morning, I guess.
You're still under. You've been under Title IX is an old law. You've been under Title IX.
I understand that part.
And you're still under Title IX.
All the new components, though. So I understand the procedural changes.
They didn't add the new components that you're referring to are at issue in these other states because their court, in applying the statute, has not ruled on the issue of whether sex includes gender identity. The Seventh Circuit, which includes Wisconsin, has ruled on that consistently since 2017. And so you have to abide by the law of your jurisdiction is what it amounts to. The fight that's going on in these other courts, or in some of these other courts around the country, is a fight that's already over for Wisconsin and the Seventh Circuit unless and until it goes to the U.S. Supreme Court and something else is decided.
So when Jeff was here 2 weeks ago, a comment came, I believe, from the audience about Moms for Liberty, and he said he checked the list and we weren't on the list, and now it appears we're on the list, all 7 of our schools. So what does that mean to us?
There's a lot of misunderstanding on that issue. The injunction involving that's from a Kansas district court, which is a lower level court than the circuit courts. You've got the 7th Circuit, you've got the 10th Circuit. Under the 10th Circuit is the Kansas district court, just like we have the Eastern Wisconsin district court is under the 7th Circuit. So district courts make the initial decisions, they get appealed up to the circuit courts. The circuit courts establish the law in that circuit unless and until the U.S. Supreme Court changes it for one or the other. And this is obviously an issue that at some point there's going to be 2 different circuit decisions, one or the other, and the court's going to have to decide the splits between the circuits at some point down the road. But the injunction from the court in Kansas is not directed at the school. The schools are not parties to that case. So the court in that case cannot issue an injunction against a school that's not a party to the case. The Moms for Liberty are parties to the case. The court's order, the injunction, which I have right here, is against the Department of Education. And the Department of Education and the Attorney General of the United States. That's who the injunction is on. And the injunction says they cannot enforce Title IX. But that does not stop someone in Wisconsin from bringing a lawsuit in order to try and enforce the law. And the injunction has nothing to do with that. The injunction does not prevent the district from adopting or not adopting any policy. The injunction has no control over your decision with regard to the policy, because the injunction does not apply to you, it applies to the Department of Education.
I didn't know you were gonna, maybe strike that language, because I agree, you're the Title IX coordinator, right?
Yes, ma'am.
And you have to administer this, and Aaron was just talking about clarity.
Yes.
I think if we remove words or sex stereotypes, sex characteristics, I think pregnancy probably would be something you'd keep in there. Related conditions, that's a very gray, ambiguous term. I think if we remove some of that language, I think that's a much better policy.
But it's still not clear to me though.
It's not
What
clear,
is
but it
this-
would be under
What does the state law say? If the state law says all of these words and we don't, it doesn't matter, right? And I'm not saying I'm against these words. We have a lot of concern out there. I'm trying to get clarity for everybody in the room. Because to me, we're in no different place than we were half hour ago.
Unless the law changes.
Understand that. But so again, back to my question, no matter what words we use, if we say follow the law today is this. This is the law in the state of Wisconsin. So it doesn't matter if you take the words in or take them out, it doesn't matter. We can leave them in, and if the policy changes or the law changes, we would change the policy at that point in time. To me, it's smoke and mirrors, and I'm not in favor of changing the words if it doesn't mean anything to us.
Well, what, aside from these words on this paragraph, because I had it highlighted also, same part, otherwise the policy is almost the same. You say it's procedural.
Other than procedural.
Other than these terms that are hot button issues, if we removed and struck these and used the definition as Title IX was for the last 52 years and adopted that policy, that would be more to my.
We would have to adopt what the Wisconsin law is, how Wisconsin defines it.
We can choose.
I'm not bound by, I'm just saying,
We
if
are bound
this
by
is a
Wisconsin law.
procedural change in policy, we can strike these few little terms here that are very, very ambiguous, and that's very hard to determine what these words mean.
I don't think it is ambiguous. I think when you talk about pregnancy and pregnancy related,
No,
that's
not
like,
pregnancy,
oh,
but
okay,
how do,
but that's
how would you
related,
describe,
that's what I said.
or how would you, I'd say pregnancy could stand, how would you explain, or how do you explain what these terms, sex stereotypes, sex characteristics, or related conditions, I mean, how do you administer that?
So
To me, there's no clarity there
So
for
let me
anybody.
answer it. So pregnancy and related conditions, if you read
Oh,
further,
the related
that's,
to
right, that's
pregnancy,
gonna
right,
be breastfeeding,
yeah.
things
The other
like that.
two.
Everything else we're taking out and putting
Yeah,
per the
okay,
law.
okay, that's a related to pregnancy, but
Right.
the other two, I don't know why we couldn't strike those, because I don't know how you determine what those really would be, that's a grade, those are very difficult terms
So
to
that's
understand.
exactly what I'm suggesting.
I agree with you,
Okay.
I didn't know you were gonna bring that up today, that was my number one
And
question.
Bob, based on Whitaker, there is a defined definition in the state of Wisconsin as to what sex encompasses, and it encompasses all that's included in this policy, correct?
So this gives us the flexibility as the law changes. Let's say Whitaker's challenged again, it gets overturned, right? That's when this would change, and it would change instantly in our policy because the law changed. If this gets challenged in the Supreme Court takes a different stance. Our policy follows that new law that that's our jurisdiction now. So we don't have to keep doing this. We follow the law.
So I would like to put a motion on the floor to remove that verbiage. So I would like to have a motion to remove the verbiage of sex stereotypes, sex characteristics, sexual orientation, and gender identity. And keep anything that has that definition labeled. I think this comes in twice within the policy, to remove that verbiage and state as applicable with the law.
So this policy covers harassment and discrimination on the basis of sex as that term is defined by applicable law. Correct.
That is
So
my
our
motion.
administration is okay with that, and our legal, so we have a motion.
I would second that.
So we have a motion and a second. So is there more conversation to be had here if we strike those?
Hold on,
We're talking 2264 here.
But are we approving the removal or are we approving the
new
policy?
The new
removal.
removal and new language, right?
I'd suggest what you're approving is the revised language, because that policy isn't in place right now. So
Right.
you don't have to remove anything.
We're gonna
It's-
amend
it's-
before we adopt it.
Yes.
So,
Go ahead.
So Bob, if we don't adopt the revised language and it's a state law, we can talk about lawsuit, right? Litigation?
Well, we're talking about federal law, basically, as it's applied in Wisconsin. So there's also a state student discrimination law, but that's a different policy. I mean, that's part of the framework, but it's, so I just wanted to be clear when you said state law, it's that we're talking about the federal law as it's applied, as it's been ruled upon by the federal courts for Wisconsin and the other states in the Seventh Circuit. That's what we're referring to.
Right, but this initial change back from 2017, as you said, was initiated by the federal government,
By a federal court decision.
and then the state of Wisconsin
Applying-
adopted it.
No, the federal court decision is a ruling by the federal circuit court that has jurisdiction, including Wisconsin and a couple other states. And so that became, so if someone brought a federal lawsuit, that would be the controlling law that would decide. So when the student brought that case in Kenosha, eventually the Seventh Circuit ruled. There have been a couple other cases since then where they've ruled consistently with that. So it's not a law that was passed by Congress. It was an interpretation of the statute by the Seventh Circuit Court of Appeals. And so our federal courts in the Seventh Circuit, the lower federal courts, have to apply the Seventh Circuit's ruling. And unless and until either the Seventh Circuit reverses itself or the U.S. Supreme Court rules otherwise, that's the law of Wisconsin. But it's not the Wisconsin legislature doesn't have anything to do with that, because it's an interpretation of federal law. So it's not a Wisconsin law, it's the federal judicial, it's the federal court system applying the law.
But hypothetically, if we, because we're the local, right, don't accept this policy and continue to operate under our old policy, because that's the one currently in effect, and something comes up, right, it would just follow the process, correct? I mean, it would follow the existing process that's in place.
Well,
It's not like, I guess what I'm trying to say is it's not like all these other protections aren't covered. I mean, our school policy today, we have a zero tolerance policy for bullying, harassment of any type. That covers everything, okay? This is good protection for us, but we already have a zero tolerance policy. And it said, whether we have to adopt this or not, I don't know. But in the end, you know, again,
What do you expect them to do procedurally
the same thing we've always done.
for an investigation?
The
But-
same thing we've
the
always done.
Okay,
the
so
updated
now-
policy has more flexibility for the district administration.
That's the part
But
we
it's not
want.
better, it's
Yeah,
not worse,
just
it's
strike this
different.
language.
Well, it's better, I
Yeah.
think it's most,
Yeah.
I think most everybody agrees it's better, it's better from the school district perspective because you have more options. And you also have an informal resolution process that's not in the old law, in the old regs. So it has procedural advantages to the as opposed to the prior system. And that's one reason where I think, you know, most of the people who have to live with this and apply it day to day are saying it's a better policy for application in the front lines.
Well, I
But
think
does
the
it can be
community has to
tailored?
deal with this on a daily basis, it's not just the staff.
But,
We heard from
again,
teachers.
Steve, the community's perspective, the focus being on who's getting protected by this law, as I said a little while ago, the law, the new regs don't protect anyone who wasn't protected before in Wisconsin. It's the same level of protection. It's just how you function once you get a complaint that really is involved with it.
And this is the part we want, Steve. Like, this is our community telling us that this is how we want this applied. We don't have a choice but to recognize the law set by that circuit court. We have to, we can't just break the law tonight. I will not direct our administration to do that. I can't do that. But this gives them the flexibility to do this Pulaski's way. Before, it was black and white. How this was applied was black and white. They had a manual. This is how we're going to do it. And now we have so much more flexibility. And if it's meaningful, Julie's prepared to take us through that application if that's what you want to hear about. But that's the part that changed for us. The rest of it didn't change.
I think it'd be a fair thing for us to walk through the concerns tonight of the restrooms and athletics, things like that the community's concerned with. How are we as a district handling that today? And then is anything changing for us?
Well, maybe I can summarize that in a nutshell, which is adopting the policy doesn't change any of that. That's all in the application of how you're going to apply. The new regs and the policy that's on the table does not go into any of those issues and tell you how you've got to handle them. That those are the practical application situations that are beyond the policy itself. The policy just covers who's covered by this and what are the procedures available when you get a complaint. In terms of how you're going to handle a specific locker room situation, you've got WIAA that weighs in with regard to the sports and all of that kind of thing. This does not dictate how you handle those situations.
And this does not include sports.
Correct.
Okay, so we just wanna make that clear. This is not, boys can't join girls' sports now all of a sudden if this were to get adopted. It's controlled in a different policy itself, and like you said, WIAA has a lot to do with that as well.
So I think we owe our administration some credit, the fact that nobody in this room really knew that we were living under these policies currently, and it hasn't been a thing. They're applying it the way we would want them to apply it, so it doesn't put kids on either side of this in harm's way. That's what we have to trust our administration to do.
Right, and I think that, from the perspective of some of the provisions within this, it'd be very difficult if this was not in place for us to be able to follow through with the requirements of the law. So for example, there are some mandatory requirements for some employees, like if we're made aware of certain circumstances, that we need to follow up on them and in a certain way. And so like in order to investigate and so forth, it'd be very difficult to, well, it wouldn't be possible essentially. So there are some requirements, and for example, if a student is, notifying somebody that they are pregnant or something like that, then they need to communicate with me so that I can make sure that they have what they need so they're not discriminated against. Now, how often does that happen? Not very often, but we need to protect everybody, staff and students, in our environment. And that's really what this is about, non-discrimination, making sure that everybody has the opportunity to be able to participate in programs and activities that we offer here. So essentially those are some things that I would really not be able to enforce or be able to investigate or follow up with for the procedural processes if we didn't have this in place.
And then that would put us at legal risk with, if you do not follow through with what the procedures are in place now, whether we adopted, if we did not adopt them, then we are at legal risk because we didn't follow the state law ultimately, or the law that's set forth for this statute, and then we're at more legal risk because Julie didn't have a policy or procedure to follow.
Yeah, and students with disabilities are also incorporated into this new process, I guess, if you will, look at the procedure in the law.
And so essentially, in the old one, there's new grievance procedures and policies or practices that we have to enforce in here. And that would allow for us to have different processes that we'd follow to make sure that we're also not discriminating based on disability. So it's really complex and comprehensive, but we need to have a process in place to be able to follow through with this. Otherwise, we'll be making mistakes and not following federal law, and that would not be something that ethically I would be able to do.
One way I think to look at it is if you have, the old policy stays in place because any complaints that come in after that deal with incidents, even if that complaints come in after August 1st, if the incident occurred before August 1st, the old policy applies. So you're going to have both policies in place. You're covering your bets in a sense by having both policies. No matter what happens on the national legal front, you've got your administration covered basically. Is what it amounts to.
And we're also gonna cover every definition as the law changes.
I still struggle that over 2,000 schools are saying something's wrong here, and we're willing to say it's okay. I don't know. I'm just saying I don't know.
Is that language we're striking the most incendiary part of this, causing the controversy?
Yes, and
So if we strike that, we've removed some of that, then it becomes procedural.
We're not striking it in a sense because
No, we're putting a blanket over the top that covers everything.
that's
saying the
consistent
law.
with the law that we must
Agreed.
follow.
Again, I'm not criticizing, I'm just making
Yeah.
a statement. It's not striking it, it's just putting a cover up top that covers everything below that's in place today.
Right.
Again, I want to be clear. This isn't about me not wanting to protect this, that, or that. It's nothing to do with that. This is about a policy and what's best for our district, our community, our teachers. Again, our students, everybody. I don't know. I struggle that 2,000 plus schools are saying, something's not right here. And some states said, well, we're going to take a second look at this. So that's the part that's holding me up. How can we say, oh, everything's great? It's got to be perfect for us.
The difference is there in those states that are suing and are in the litigation right now, their federal courts have not yet decided the issue that our circuit has already decided. So, and different circuits may decide that differently. That's why I always say that's why they build courthouses. Lawyers don't always agree. And so, you're going to have differences out there. But as Dennis pointed out, where you're getting all the litigation and confrontation and controversy is where they still have not yet defined their term in their circuit. And so the courts are battling that out right now in some states. So the fact that there's 20 states that have gone after it, they're primarily focusing on that issue of the definition of sex. Our circuit has already spoken on that issue.
Right. But not this policy or any other policy we ever implement in a school district is going to change behaviors or manage behaviors other than the people in this room, the teachers in the buildings, and the kids in the classroom. So I have no.
That's where it gets applied, right?
That's right. But I get the procedure stuff, Julie. I understand all of that. But so for how many years, 50 years, we've had procedures and they've worked. We have anti-harassment policies and discrimination in our schools already. So again, there's something here. I don't know what.
One of the questions that continue to pop up is the restroom usage of girls using restrooms that are girl restrooms, etc. We've heard all of those. Does this impact anything in the schools where that will be be allowed? I'm not saying that right.
Yeah.
But you know what I mean? Like, is there anything in this policy, if we accept it, that will say, oh, that's okay?
There's nothing new in that regard. So essentially, we have plans in place for all students who come to us with those needs. And so those support plans are very clear